Welcome back to Canadian Justice, where we are discussing a legal challenge to Canada's voting system that was recently dismissed by an Ontario court. Now, Asher, the group challenging Canada's election system, our first past the post system, they challenged on the basis of the charter. They said it violated the charter, and part of their argument was about Canada having a living tree constitution. How did that work into their arguments? And I mean, can you explain that principle? And what exactly do you think they're getting wrong about that principle?
Right. Well, the living tree, the phrase living tree is an old phrase that comes from a decision almost 100 years ago called the Persons case. Now, when it was said at that time, it didn't mean what it has since come to mean. It basically meant that our overall constitutional system must be capable of evolution. It didn't mean that you interpret the Constitution differently from one day to the next. And it certainly didn't mean that judges could change that interpretation from one day to the next. Since then, what living tree means has evolved. It means different things depending on who's talking about it. In its most aggressive form, and candidly in the form that the applicants were putting it, we're using it in, it essentially means that it is the role of judges to update our Constitution when they feel it becomes out of date, when it no longer reflects the values of Canadian society. Of course, who determines those values? The court that is being asked to apply the provision. And uh, candidly, I think the applicants needed the living tree in this case because it was so obvious that first past the post sat comfortably in our constitutional order historically. As Christopher said, first past the post was very clearly constitutional at the time the charter was enacted. That would have been the time for the framers to reevaluate our system, and if they had any problem with it, replace it at that time. So it was almost necessary for the applicants to say, well, maybe it was constitutional 40 years ago, but it's no longer constitutional today. And even the very idea of uh, different constitutional provisions sitting on that same equal level, on the same level of the legal hierarchy, it seems that even that principle, the applicants were implicitly arguing, I would say, that that may no longer be the case, that the charter seems to have some higher level of importance than other constitutional provisions, such as the electoral system provisions.
Now, Christopher, one of this is this quote about the living tree from this person's case so long ago. People who cite it frequently cite just, Canada's constitution is a living tree capable of growth and evolution, but they leave off the second part of that sentence, which is within its natural limits. And in our argument at the court, we reminded the court about the second half. What can you tell us about what those natural limits are and how they might apply in this case, and if the court made any findings about that?
Well, quite simply, Christine, the natural limits are the text of the Constitution, what the Constitution actually says. And what the Supreme Court has said on other occasions, and which Justice Morgan cited in this ruling, the text of the Constitution is not an empty vessel to be filled with whatever meaning we might want from time to time, which, as Asher has explained, is essentially what the applicants were attempting to do in this case. What the court, or rather the Privy Council, meant in the Persons case almost 100 years ago was really a broader point about how Canada's constitution would evolve and how Canada's constitutional destiny was not tied to the constitutional destiny of the United Kingdom. That the United Kingdom jurisprudence, which had arisen since Confederation, did not bind the growth of the Canadian Constitution. But this hardly means that, as a matter of methodology, the meaning of the Constitution is this open-ended thing that can get us to whatever policy outcomes we want. So in a lot of ways, those who advocate for the living tree aren't really advocating for a methodology, in my opinion. It's more of a non-methodology.
Yeah, and did the court cite any of that? Did they have any findings in this case about the living tree, Chris?
Yes, toward the end of Justice Morgan's reasons, he raises the living tree, which is a point we raised in our factum and a point that we made in our closing submissions in court. and essentially said that the living tree doesn't help the applicants here. It doesn't get them to where they want to go, precisely because the living tree has to be capable of growth within its natural limits.
Exactly. It's that second part that's so important that people just conveniently leave out. We've got to go to commercial break now, but when we come back, I want to talk about the voting system that we do have and the possibility of change not through the courts, how that change could be effectuated if the government wanted it to.